Welcome to Rocinio Law. Here's your host, Albert Rocinio.
Today I wanted to talk to you about domestic violence. Domestic violence in New Jersey is a civil offense, but if it's a second offense, meaning if it's a violation of a current restraining order, it is prosecuted by the county prosecutor's office and you could face jail time. And for a third offense, if you're convicted, it's mandatory jail time. So it is a sort of a statute that both is civil in nature and is criminal in nature, has criminal implications and overtones. If you're charged with an act of domestic violence, please immediately seek competent counsel of attorneys that deal with this. The first thing that you have to remember is while the domestic violence statute is contained for New Jersey in what's called our 2C section, which relates to criminal offenses, it is a civil action, meaning the standard of proof is a preponderance of the evidence versus a criminal action where every bit of the standard of proof for every element is beyond a reasonable doubt. And the difference is huge in the terms of proofs that the plaintiff or a prosecutor need to make. The burden of proof by preponderance of the evidence would be an ever so mere tipping of the scales of justice. A little to the right, a little to the left. Consider, if you want to talk percentages, 51% to 49%. That 1% is enough for preponderance of the evidence to carry a finding against you. Versus, say, a criminal matter, which is a preponderance of which is a burden of proof of beyond a reasonable doubt. And that is a very high standard. I don't know, there's never been exactly a percentage, but figure 95% confident that you're guilty of something, and that would be beyond a reasonable doubt. So you could see the vast difference in the burdens of proof. In a domestic violence trial, prior acts of domestic violence are always admissible, and if you're charged with it, you want to be prepared to defend against those. And if you're the victim of a domestic violence, an act of domestic violence, you want to make sure that your temporary restraining order contains those. If it does not, you go and you get the restraining order amended. It's called an amended TRO. Very important, because technically only those incidents which are listed in the temporary restraining order can be testified to. I've had clients go back and list 20, 25 prior acts of domestic violence into an amended restraining order just so that we could testify as to those. And that plays a big part in a mental state of mind of the victim and the ability of the court to weigh that evidence and find whether what's called the predicate act, that's the current act, is going to be met. So in some instances where you have a current act that might not have met an act of domestic violence, you have the weight of the prior acts of domestic violence that could give context to it, that could let a judge decide, you know what, this was a real threat. You know, this person had a right to believe it was a real threat. This person had a right to have a legitimate fear. And you have to express to the court, if you're the victim, that you have a legitimate fear. On the flip side, if you're defending it, you want to prove to the court that there is no legitimate fear. I've prosecuted, I'll call it prosecuting, and defended probably hundreds of domestic violence cases, and have been involved and have seen things that are just horrendous. Both sides. I've had cases that I've had the courts dismiss at the conclusion of the plaintiff's case because they failed to meet even the threshold burden. But you have to know what you're doing. For example, I had a case many years ago, and I'll tell you the facts. A guy texted his ex-wife and said, when I left the house, they were divorced at this point. When I left the house, I left the Christmas lights in the basement. Would you put them over the fence or leave them on the porch, and I'll pick them up when I drop the kids off? That was it. She went and filed a restraining order. We got to court, and she put on her case. I got an opportunity to cross-examine her. And when I did, and pardon my French if I use any, colorful language. She had texts between them, and I made her read those texts to the court. He would text his wife and say, his ex-wife, and say, we're at the parade, it's cold out, and I'll just use a little boy's name, Timmy. Timmy's cold, where's Timmy's jacket? And she would text back, F you and your effing bitch whore girlfriend, go F yourself. And it was not once, but it was repeatedly throughout their text. He'd say, could you tell me what time, or where I'm going to meet you to drop the kids off, or anything, that was just innocuous. And she would text back, F you and your fat bitch girlfriend. So I made her read all of these in court in front of the judge. And I made what's called a motion at the end of her case. And I said, Your Honor, I said, what do we have here? I said, you can poke the bear. I said, you could kick the cat because you feel you're going to get away with it. But you don't poke the bear because you don't want to get your head taken off. So which is it? Is my client the cat or the bear? Clearly, after having seen all of the interactions between them, the judge was determining that my client in this case was the cat. She had no fear of him. She could talk to him any way she wanted. She could treat him any way she wanted without fear. On questioning, the judge asked this woman and said to her, so all he asked you was to leave the Christmas lights over the fence or on the porch? And she said, yes. He said, he didn't ask to talk to you, right? She said, no. He didn't ask to come inside the house, did he? She said, no. And the judge said, all he asked you to do was to leave them over the fence. There had to be no interaction between you. And she said, yes. And the judge said to her, and that's why you filed a complaint for domestic violence? And she said, yes. And the judge literally crossed her arms, sat back, looked at her and said, okay, what else do you got? And at the end, after I didn't even technically present the case, which is how bad this was for her, the judge said to give you a restraining order would make a mockery of every legitimate restraining order ever given. So my point here is, and in telling you this is, you have to do your research. You have to know your case. You have to present your case properly. I had another case where the predicate act was very weak, but there was lots of prior acts of domestic violence. And this is one where I had my client amend her restraining order, like 25 counts of prior acts. And knowing that my case on the predicate act was weak, I tried all of the prior acts first, sort of reverse order, to make sure that the court got an earful. And there was video recordings, there was audio recordings, the guy locking the wife and the little girl, or she was actually his girlfriend, and the little girl who was his daughter, locking them out of the house in the winter, in the cold. The kid didn't have a jacket, and she's going, Daddy, I'm cold. Mommy, I'm cold. And he would not let them in the house. It was sad to hear. The court, now I'm letting you all know this, the court did not grant that restraining order for the act that actually happened, because you're not trying the old act, but you are explaining them for context. But what the court did do, and what I hoped the court would do, was the court found that there were prior acts of domestic violence, that the guy was a liar, that the court did not believe him, and put it on the record such that if he ever came back to court with her again, any judge seeing this decision would automatically find that there are prior acts of domestic violence. A very, very big win for the client. Again, you have to know what your case is. You have to know what your strengths and weaknesses are. You have to present your case in the best light to maximize your strength and minimize your weaknesses. No one should be a victim of domestic violence. I defend these cases. I prosecute these cases. I've seen bogus cases, as I've explained to you. I've seen real cases. If you feel that you're a victim of domestic violence, please call the police, seek help. There's counseling. There's what's called the cycle of domestic violence, where abusers keep abusing and those being abused keep allowing themselves to be abused. And it's bad for the parties. It's bad for the kids. When the kids see this, then they can become abusers more likely. Take a step, if you're a victim, to get out. to seek help, to do what you need to do to break the cycle of domestic violence. And domestic violence is not just men against women. It can be women against men. It can be the old against the young or the young against the old. It can be relating to children. Or children could be, depending upon their age and what they're doing, they could be the perpetrators. But in New Jersey, there has to be some type of familial or dating relationship in order to be an act of domestic violence, in order to get a restraining order. Please, I take this very seriously. I hope that you all take it very seriously. I say to you all, do the right thing. Get out. Don't let anybody lay their hands on you. Don't be a victim of domestic violence, whether verbal, psychological, or physical. And seek the help that you need and move on. Your life and the life of your loved ones, your family, your friends, everybody will be better for it. Thank you for tuning in. Like my video. Please join or subscribe to my page. And I look forward to seeing you all again.
Thank you for watching Rocinio Law. Please do not forget to like and subscribe.